Maggie Grover. Turn it over to Maggie Grover, the employment section leader for 2022 and the organizer of this amazing series. Thank you. Go.
Thank you, Anne. And just right off the top, let me announce that this is the first of 3 nuts and bolts programs we have. The next one is on September 20, and it's preparing for mediation in the employment case. And the last one is on October 18, and that is selecting a jury for an employment case, which is different than selecting a jury for a rear ender or a med mal case. And we are very, very fortunate to have secured some talented speakers today. Let me start with Marta Vanegas, who is our actress extraordinaire, she is principal at Vanegas Law, does mostly employment law work, has both an JD and an LLM, and I think an MFA that she's hiding on us. And she does a great job at litigating for her clients, and she is playing the role of the plaintiff for us today. And her attorney is Terry Leoni, and let me flip to my. Terry is a plaintiff's employment lawyer. She's been with her own firm since 2016, focusing also on labor and employment law. She is currently on the Contra Costa County Bar Association Board of Directors. Now say that 6 times fast. She's been recognized as a super lawyer in employment and administrative law for the last 4 years, and is often called the lion of the employment law bar. She came to work for the Contra Costa County Bar almost immediately after graduating from University of California at Santa Barbara. And she has just been dedicated to various activities in the Contra Costa County Bar. Audrey G is another individual who is deeply involved, has served as president of the Contra Costa County Bar Association, and has headed several of the sections. You can always find her at some level of involvement. She is our defense counsel today, and she plays a defense lawyer in real life as well. Again, a woman with an excellent reputation in the field. She's a volunteer discovery facilitator, and she's about to just take her first child off to college at UC Pomona, right? Or
Cal Poly Slow.
Cal Poly Slow. Another bright child. And Marissa, I'm sorry, I'm trying to find what I wrote down for you, Marissa. I cannot see on my on this little tiny screen. So she's also at Brown G and Wenger. Did I say that right? Yeah.
That's right.
And she is an labor and employment defense attorney. She does wage and hour class actions, trademark prosecution, and brand protection guidance, which sounds actually, I think, more fun than it really is.
Yes.
She's worked with startups to multinational corporations, and she doesn't use her right pinky finger when she types, which, I don't know, does that slow you down?
No, I feel like it's slower if I try to type with my pinky's short. I feel like it's
well, interesting. Someday we'll all get to watch. Today we're going to be talking about client intake. The first pair to go through client intake is going to be Terry and her client Marta, who's also known as Maria Campbell. And Maria was raised in a very conservative family. She came to work not long ago for Works Is Us, and she had been out of the work environment for years raising her family. She's an administrative assistant for Brett Knorr. Brett is 50 and has never been married. Marissa has gone through a sex change operation. Brett dates many women, enjoys hanging out, drinking. He likes beer. You may have heard that someplace else. And he has made some comments to Mary that she's found terribly shocking. I'm not going to read all of them to you. I'm going to let Marta and Terry flesh out the situation, and Marissa and Audrey are going to flesh out the situation on the other side. Maria did eventually speak to HR, who conducted an investigation, and excuse me, Maria was not able to effectively communicate her position to HR, and she felt that Brett was retaliating against her because she had turned him into HR. So the two of, again, please put questions in the chat box. I will read the questions as we have little breaks, but I want this interview to unfold naturally. So Terry and Maria, Marta, please take it away.
Thank you, Maggie. Let me switch to gallery so I don't see just my face. And yes, we do love questions. Please feel free to ask. Marta and I actually haven't really planned this or rehearsed much because we wanted it to unfold, like Maggie said, kind of like real life. But before we start with the actual process, I wanted to talk a little bit, and Marta and I want to talk a little bit about the intake process. Of course, you know, the intake should be a screening process for us as well as the client. I think not just for the facts or, you know, how much money is at stake, but is this going to be a good client for you? I'm frequently leery about doctors, educators. It's really hard for me to deal with people in the educational system and attorneys. I find that they're very difficult to deal with. And, you know, if we have a lot of emotional clients, you know, do you have the bandwidth to handle that? You know, you have to have kind of look at your professional responsibility, your competence, what you can handle, and the ethical issues. You know, do you have the know-how for the background for the emotional clients? And I am very good, I guess I'll say, about not giving legal advice on intakes. I think, you know, you want to ensure that you are not entering into an attorney-client relationship. I remind the potential clients of that, you know, throughout. I don't want there to be, because if I do give legal advice, I don't want there to be, you know, someone that comes back with, let's say, a malpractice claim. Hey, you told me to do this, because we're just getting the tip of the iceberg in these intakes. So we don't want to give bad advice or incomplete advice, or again, create some sort of unknowingly create an attorney-client relationship. And I don't know how everyone else works, and I'm sure, you know, Marta and I have talked about this, but I am generally strict about a very short initial intake process. So my process works, I have an intake online where people can click that, or if someone calls, you know, the receptionist will give them the intake process, or if someone emails me, everyone has to complete an intake. And then I get the email, I review it, and I'll either have my assistant schedule a call, and I'm very strict about just keeping it to 15 to 20 minutes. We have so much that we have to do. Like I think before today, I had 4 to 5 that I have to do. So I think keeping it short, and occasionally if I don't get enough information on an intake like we have today, I will ask for more information and we go from there. But, you know, sometimes if there's a conflict or just, you know, it's not the type of case that I want to deal with, it's an automatic declination. We'll send an email, move on, or we'll offer a 1-hour Zoom consultation if we think that there's more information that they need, or like today, the 15 to 20 minute call. So I want to share my screen and go through a little bit before we start. Marta, any comments or thoughts on that?
I mean, as to providing legal advice, I always tell the clients I haven't really evaluated your statute of limitation, but generally you have this much to go to the DFEH and you have a much shorter time to go to the EEOC. And I tell them not to delay, because cases don't get better with time. They are not fine wine. But it's also kind of a good idea to remind the client that there are statutes of limitation that we consider on the onset, even if we don't take the case. And the other thing is, I often send clients away because I'm not feeling too jazzed about their case, or we don't align politically. for example, if they are claiming some weird basis of discrimination that I believe doesn't exist and don't want to further their cause, then I would be like, "Oh, but if you feel you were discriminated against, you can go to the state and submit this case to them and they will look at it and investigate." I don't think that giving a well-intentioned direction to somebody that they could have otherwise found on the internet is going to land me in a malpractice suit. If so, we will see how that pans out, you know. That's all so far. Back
Yeah.
to you in the studio.
I mean, good point in terms of statute of limitations. I do try to put that in declination letters if I'm not moving forward. Hey, reach out or refer them to the Bar Association. Also for my intake, I've tried to make the logo smaller. My assistant has as well. We can't quite figure that out, but I do put this on every intake to ensure that people do understand that we are not, just by completing this intake, there's no attorney-client relationship. We try to respond within 24 hours. So here's Maria Campbell's. We got this recently. My assistant scheduled a call. I like to grab their date of birth. Obviously, if there's an age issue, I want to know if they're over 40, you know, if they've been terminated, I'll talk to them about that. Sometimes if there's criminal issues, I'll want to look them up online. I have a lot of clients who are public employees and tend to give me their work email. So I try to ensure that it's a personal email. Obviously, we want to know where the client is located or the potential client. And here's what happens. I request a detailed description of the issue. And sometimes we get just something very short, sexual assault at work. You know, that may be sufficient for other people. So what we did here, Maria, aka Marta, filled this out, just said sexual assault at work. I emailed her to ask for a little bit of information, or often my assistant does. Can we get a little bit more information? She responded that she was uncomfortable with that because of the nature of the issue. So we went ahead and scheduled the consultation. I think it's important to ask for the date of the most recent incident. I like that this has happened, you know, recently. I'm often a little leery. It seems like a red flag if you get something that happened 6 months ago or a year ago. I want to know, hey, what's happened between now and then? Have you contacted other attorneys? Why has there been a delay? I'll often ask that sort of straight away. And of course, the name and location of the employer. For me, the conflicts check is generally just the employer. Have I worked with them before? Have I represented them before? I have a small, employer-focused business, where they're located, the venue, we want to know that. And for me, a red flag as well is how long has the potential client worked somewhere? 3 months to me, if they're having issues, can be a red flag. You know, if they've worked there for 20 years and then they've gotten fired. So I want to know how long. That also is, important for a damages calculation. The job title, we want to know what they've done. Again, important for a damages calculation. I'm not going to right off the bat ask what their salary is. Again, I do a lot of union work, so I ask this. I also like to know if there's been any complaints filed, if they have another attorney, things of that nature. What I want to know prior to going into the intake. I also do like to know the referral source so I can thank them afterward, or if it's another attorney, if they have, a provisors group, something like that, or if they've just found me off of the internet. So without further ado, let me take this off. And we will get into our role play. Again, Marta and I haven't practiced this, so it will be pretty similar to an intake that we normally have. All right, Maria, how are you today?
Well, I'm okay. I think I'm coping well with what happened to me.
Yeah, I understand that these are very difficult circumstances, so I appreciate you contacting me and being willing to share what's going on. Now, we had you complete an intake, and I know we reached out for a little bit more information and you weren't entirely comfortable. So what we have right now is that you worked for Work Is Us, and that you thought that there was a sexual assault at work. So again, I'm very sorry to hear that. I know that this can be difficult. So I want, if you are comfortable, tell me a little bit more about what happened and, you know, what it is you're looking for, if you know.
Well, so I think you need to know a little bit about me and how I move through life. I was raised in a very strict conservative family, and I was always taught to be very modest in my appearance and to not let men leer at me and objectify me. And I prided myself on being able to remain in a faithful, committed relationship all my life with my dear late husband. But unfortunately, after his passing, I had to enter into the workforce, and nothing is the way I thought it would be. Nobody respects my personal space, and especially my boss was always kind of hanging over me and leaning over me, and I felt that he was just getting really close in my space and barging in and touching my keyboard and kind of pushing me to the side, and I tried to scoot over just so that he would not be like touching my breasts with his elbow or with his arm, and he did this a lot, like a million times. This was his habit, and even before he would grab my keyboard or my mouse and make a correction, he would just stand and hover over me and kind of look over me. And even though I'm kind of covered up at all times, it still made me very uncomfortable. I got to feeling very, very uncomfortable at work, and I eventually reported him to HR for this. Oh yeah, and he also asked me out. You want to hear about that? He totally asked me out, and he asked me out to drink alcoholic beverage with him right away. I did not even, it wasn't even a week into my employment when he said he would like to get a beer with me. And I never ever in my life had a man ask me out just so casually, and I'm not accustomed to socializing with men after work. So I kind of just mumbled something to decline and ran home. But I was absolutely offended by his implication that I would just go out with him right away after working for him. And what else happened before I went to HR? I just want you to get kind of a chronology. I saw him undressed in the office. Like, I could not believe my eyes. There I am, this is like early mid-afternoon, and I just see him like take his clothes off. So I reported him to HR, and
what did HR do?
okay, so how was it? I reported him for HR when he asked me to take my clothes off. Okay, so take some of my clothes off. And so I reported him to HR, and they interviewed me, and I told them everything just like I'm telling you now. It was 2.5 hours. I talked, and yet they came back and they said that they did not believe that he violated any law or policy, but that they wanted to facilitate better communication between us and try to hold a meeting. And it was a terrible meeting. It was absolutely horrible because, first of all, they just told me that they think that I just made it up. They think that I was not harassed. They think this is a big nothing burger. And then immediately they pull me into this meeting with this guy. And he's like, well, I didn't know you had any concerns. Tell us your concerns. And I could not tell him a thing because I just felt so humiliated to be called into this meeting and explain myself when I just explained myself
Yeah, it
to
was hard.
HR.
It was hard to
Yeah.
meet him. Now, I think you had a brief exchange with my assistant and did say that you're no longer working for Work Is Us. So, and we have a pretty short amount of time, so I'm going to ask you some questions just so we can get to the heart of it. And sort of breaking the fourth wall. For me at this point, talking to everyone, I think I'd probably see dollar signs, right? He asked her to get naked. He was naked in the office. HR didn't do anything. So I really want to try to flesh this out at this point. And I like to have the potential client speak to see, how articulate they are, if they're emotional. And I want to hear a little bit more in the beginning and then follow up. Okay, so Maria, I think you did tell my assistant that you're no longer working there. What happened? Why aren't you working there anymore?
So after that meeting, even though it was apparent to him, it should have been apparent to him if HR talked to him about what I complained about, that I don't want him to come into my personal space and just be that uncomfortably close to me, like almost rubbing shoulders, rubbing elbows with me. He again came and was correcting my work at my desk, and he totally grabbed me.
Before we back up, let's talk about that, because I know the initial intake was a sexual assault, and I know this might be difficult for you, but can you describe what happened before and how he grabbed you? I'd like to hear a little bit more about that.
Okay, so he was instructing me on how to fill out this new form that we didn't have before, and apparently I made a big mess of it, or I didn't do it correctly, whatever. And he stands like right here, right next to me, and all of a sudden he just like grabs my shoulder, but kind of with his fingers kind of forward. I'm trying to show you like this. So he touched the top of my bra cup with his fingers as he was like, and he pulled my shoulder back, like yanked it back. And
was he falling, or was that an intentional act? And did he apologize, or what happened?
I don't know if he was falling. I'm not, I have no way of knowing, because once I felt him grabbing me and pulling me, I just felt like I don't know where this is going. Like it was like such a violent thing to happen to me.
Okay.
I jumped up and ran away, and I never went back. I was like, I can't work like this.
Okay, understood. And are you in an open office, or is this in a private, like a cubicle, or are you in a private office?
So it's not an open air office. I'm in the vestibule in front of his office. So people could walk by and see me sitting there, because there is a big glass enclosure there where I'm visible. So yeah, if anybody was looking there or walking there and see him grab me, that's absolutely humiliating.
Understood. And so let's go back to the beginning. You said the load my intake to the chat. I think Ann Wolf can email it out to everyone. So he asked you out for a beer. Well, let me ask you, how many other people work in your department or division? Are there only other women? Are there other men?
It's about half, and it's
Okay.
about 15 people.
And do you know if he's asked anyone else out for drinks or a beer? I
think he's a big womanizer. He goes out to drink with women all the time.
But do you know that for a fact, or are you just?
I think I've heard it in the office.
Okay. Have you seen him go out for drinks with any of the men?
I don't recall.
Okay. And do you know, let me ask you, did it seem like he was asking you out for a date? Or you said it was within that first week that, you asked? Did it seem like he was just because you were a new employee?
So I think it was the Friday afternoon, and he said he wanted to get me know a little better.
Okay.
And I think he winked at me, but I mean, he wears glasses, so I'm not entirely sure, but
Okay.
I'm just not the kind of person who goes out to drink to get people to know each
And-
other. And I think my work speaks better for
Did
my
he ask you
quality.
out? Did he ask you out after that? Once you said no? It sounds like he didn't.
No, he did not ask me out after that.
Now, you mentioned him kind of standing behind you. Did he did you see him standing behind other people at the office?
No, I didn't. I don't go around the office a lot. I was very new, so I just tried to be nose to the grindstone and learn everything that I needed to learn.
When he would stand behind you, did he ever make sexual comments, or was it work related?
I think people nowadays talk a lot more casually about their lives than it's not the way I was raised. So I think he kind of was saying things like, I had a fantastic date this weekend, or I used to have this really fun girlfriend, those kind of comments. He did
Okay.
make those.
Now I want to get, again, I know this might be a little uncomfortable for you, but you said he got naked in the office and asked you to take your clothes off. Let's chat about that when he was naked in the office, or he took his clothes off.
So he went out running during his lunch, and then he came back, and his office has this door with a kind of a transparent but not entirely see-through glass. It's kind of blurred like my background, and I could definitely see him go into his office, close the door, and right there in front of the door take all of his clothes off. And the man was buck naked, and there was only this and I could see him getting naked right next to me.
Okay, understood. And then when did he ask you to take your clothes off?
That was about a week later or two. We had a brownout and there was no air conditioning and got really, really hot, but I was fine. And I was just complaining that it was hot and I was getting a little lightheaded or was getting a little headache. And then he said to just focus on my work, and if I'm too hot, then I should take off my jacket.
Okay, and that made you uncomfortable?
Yes, I don't expose my arms in the office. It was a very thin topper that I was wearing because it's the summer, but I just felt like it's inappropriate for my boss to tell me to take clothes off.
Okay. So I'm going to think about this a little more. Our time is kind of, wrapping up. What I want to ask you, do you have any questions for me right now?
So, I took this job because I have 5 children, and my husband passed away, and whatever we got in life insurance, because dear Henry was really a cheapskate. It's not covering a lot. So I don't really have funds. So if we decided to sue them, then you would do this on that kind of fee where I don't pay you anything unless you win. Can we do that?
Sure, and that would be a contingency. So I want to think about this a little bit further. And what I'm going to do is have my administrative assistant email you and request a couple of documents so I can evaluate this a little bit further. But what you're asking is a contingency basis. And I work sometimes on an hourly basis and sometimes on a contingency. And depending on how that works, we might ask for a small retainer, and then we'll take between 35 and 40% generally of anything we recover. But at this point, I want, like I said, I want to sit on this for a little bit. We'll probably ask you for a few more documents, and then we'll follow up at that point.
Okay. Well, thank you for listening to me. It's so good to be able to just tell everything I experienced. That it was absolutely horrible. So I thank you for your time.
You're welcome.
Thank you for that delightful and real to life interview. I'm going to turn it over
Well, I
to
think we had
Audrey.
a couple follow-ups.
Yeah, there were some questions in there.
Yeah, I was going to ask the questions later, but if you want to do the questions now, that's fine.
And I think for me, and Marta can speak to this, this wouldn't be a case. I think some things sometimes people just want to be able to talk about things. I wouldn't take this case, I think, moving forward, obviously just based on things that happen. But there was a question, and I can follow up at the end, or Marta, but there were a lot of red flags to me, including the length of time, and in terms of ethics, proof is an issue, and whether there's actual violations of the law. And I really think, I don't want to be a Michael Avenatti just trying to extort people for money, especially if there are sexual assault allegations. To me, it sounds, we'd have to flesh that out. Was he falling? He just grabbed her shoulder. Is she sort of an eggshell plaintiff? And in terms of emotion, I do want to see how articulate someone is. Can they, would they be relatable to a jury? What types of issues occurred? And again, we can ask more at the end, but I wouldn't take this case. I don't think moving forward. Marta, what about you?
Oh, I'm absolutely agreeing with you. I was kind of trying to do what a lot of my clients do in the intake call. It's kind of a bait and switch. So they tell me that they were terribly abused. And then if I push them a little bit, it turns out that somebody was just falling and grabbed onto their elbow. So that happens more than you can imagine. And it takes kind of a giant patience to weather those phone calls and still appear sympathetic and understanding as Terry did, even if you are kind of like, I can't believe that, I can't believe that you think this is outrageous conduct, such as a lawsuit should be thrown at them. But as Terry said in the beginning, it looked very promising, and it could have gone if Maggie wrote it that way, the story could have gone into the multiple digit zeros, three zeros after realm quite easily. So,
and I think for this type of client, sometimes I don't during the initial intake give them an automatic declination. I mean, oftentimes I do need to follow up, or I want to see what types of communications there were. But I think in terms of, I might call them back or send them an email just so they, both of us have time to digest, or so we can, decline them in a nice, easier way.
And Terry, this is Audrey. In your declination letters, do you put the reason why you're declining? And then do you also give other referrals in terms of names and other information?
Depending on the case, if there's a conflict or something else, if it's not my area, I will refer, for instance, to you, Audrey. I've done that before, or to Beth Mora, who's here. If it's, I think there's a reason why I'm not going to take it. If it's a case like this where I wouldn't want to pawn someone off on someone that I like, I will often give them the Bar Association phone number, the lawyer referral service. But in my declination, usually it's an email. I'll say I have sort of a general template, or workload or conflict. And then I also give them the statute of limitations if there's something like that. And if I want to have a more personal contact with them, for instance, someone like this who is very upset or believes that they were sexually assaulted, I'll put something a little bit more personal in there.
Thank you. And Marta, you said you don't give names. Can you tell
I
why?
don't, so I don't give like, oh, call this person without talking to that person. And I usually just give like people who are definitely focused on that particular area. So for example, if it's a very thorny public employee, I might direct them to Marjorie Wallace but not without talking to Marjorie. Or if it is like a disability case where you need to kind of have that specialty really drilled in, then I would go to
Beth.
to you, of course.
Oh, no, I said Beth, because I think
Beth
she's
Mora.
in the audience. I saw
Yes,
her.
definitely. Or
Right, yeah.
you know, if it's an educational disability, which we do, but not all of them, then I would go to the Derby firm. So yeah, but more generally, I do point them to the lawyer referral service, because that's where they would the quickest get somebody to hear them out. And I also tell them it's just my perspective on contingency representation. I have a specific perspective on how I want to do cases and what cases I want to do, and feel free to shop your case around. If Terry is right, though, it's very tricky to decline a case in a phone call. So it sometimes is better to not do that. Unfortunately, I just blab it out all the way. You know, I just want to be over and done with. But it can totally backfire.
If you do it in a phone call, do you not also follow up with a letter or email so that you've got a paper trail as well?
Yes, I do both.
Okay.
I do as well.
Yeah, Terry, I wanted to comment on one thing. Your listening skills are amazing. And one of the things that you continued to say was, I understand. And that was enough to keep Marta talking. And I thought that was a wonderfully skilled interview. So I do think it's time to turn it over to the defense corporate side. Audrey and Marissa, are you guys ready?
Sure. All right. Hi, everyone. Audrey G here, and Marissa Boyd right here above me on my screen. We're going to do a series of maybe kind of 4 snappy scenarios, and we're going to have kind of Q&A right after each one. So if you have anything in particular, go ahead and put it in the chat and ask your questions, and we'll just address it while we're going along. So with that, Marissa, take it away.
Oh my gosh, thank you for spotting my tech so quickly. Jim from Work International said you were fast, and he is totally right. Anyway, we have this huge emergency where one of our admins, Maria, made some sort of noises about sexual harassment. She's super shy and she has some crazy ideas on personal interactions, and she because it was awkward to sit in her office, and it seems like a total mountain out of a molehill.
Okay. Can you hold on just a second? There's a lot of information, and before you tell me any facts or anything confidential, I really need to know who you are so I can be able to run a conflict check. I need the names and the spellings of all the people involved, any sort of witnesses, investigators, as well as the names of your company's officers.
I mean, is this all really necessary? I don't really have a ton of time. I'm very busy with work. Can I just waive the conflict check?
No, we have to do the conflict check. It's really important to see if I actually represented Maria before, or maybe someone in my office might have done her will or her trust, or maybe she has an LLC, we might have represented her in her LLCs. So it's really important that we actually do what's called a conflict check.
But our parent, Work International, is already your client. I mean, this really shouldn't be necessary. I mean, wouldn't your representation of our parent cover us as well? I mean, we're pretty much the same company, even though I guess we're technically a subsidiary, and I do think we have different investors, but I mean, same.
Yeah, no. So we do represent your parent, but our representation of Work International doesn't cover your company. In fact, it's super important that my firm respects the separate business structure between the parent company and its subsidiary. They're separate entities for important reasons. For example, it's important that you treat separately for avoiding any sort of alter ego purposes or successor type liability, and not treat you as the same business. Your London-based parent company wouldn't be too happy if there was a big lawsuit against you. Its California subsidiary, which drained down all your assets and had the plaintiff looking to chase the parent company as essentially the same company. So we want to say that your assets are your assets, not your parents, and that your businesses are separate. And so because you're separate entities, and both of you want my firm to represent you, it's important that my firm's practices that we have to actually disclose our representation to both of you and to obtain waivers from both of you. So we're going to need to do that. Okay.
Gotcha. Well, it's not, the parent really isn't involved. It's just Work As Us Inc. And then there's also one manager who's being accused of sex harassment.
And what's his name? The manager?
It's let me see, Brett Knorr, Knorr. I mean, to be honest, I do hear he can come off a little bit creepy, but he's a very high performer of the company, like one of our best salespeople. So
Okay, hold on. Again, we can discuss all those details once you pass conflicts. And can you spell your name and what's your title?
yeah, my name's Jenny, Jenny, and then Wright, Wright. I'm the CFO.
Okay, and who's the employee and what's, just kind of like in a really tight snippet, what's the potential claim against the company?
So it's Maria Campbell, I think Campbell, yeah. So Campbell spelled Campbell, and then she is accusing.
So
Brett.
hold on, actually that Campbell rings a bell. Do you know if she's related to Arturo Campbell? I've met him a few times and we're both board members of a professional networking organization. I think he might be a banker.
I think he might be her uncle, but I have heard his name before, but I'm not 1,000% positive.
Okay, we might have to check it out further. I know Arturo from this networking group. I don't work with him. I haven't referred any clients to him. He hasn't referred any clients to us that I think, but I'm going to have to double check that.
Can I just sign the waiver now? I've been at a lawyer's office before, and I don't think I've ever read the waiver. I mean, I just sign whatever they put in front of me, you know?
Okay.
Can you just do that here?
No, I'm going to need to check conflicts. I'm also going to need you to read our disclosure of our representation of your parent. And I will need to get both of you and your parent's signature on the conflict waiver. I'm going to want you to take the time to review it, and you should have the opportunity to discuss with independent counsel about what it means. And once you sign that, we can discuss your situation in more detail. I'll send you along our engagement letter.
Good.
Okay, so scene, and that's it. So oftentimes, this happens and a client will call you up and they'll just start like, blah, telling you everything about their case before you've even passed conflicts. So I usually stop them at the very beginning before they even start telling me any detail. And we just want to make sure that we're passing conflicts. And then in terms of the parent subs, I get that kind of confusion all the time, particularly if there's like serial entrepreneurs and they have lots of different LLCs and they all think, well, I'm the same guy, so I can go ahead and represent, or the firm can represent all of my people without even passing conflicts. Here we set it up in a parent sub situation. And again, there just may be different investors. You have to do the disclosure. You'll want to be looking at Rule 1.7. In terms of written consent, it's 1.7A versus disclosure, which is Rule 1.7C. I guess we'd want to know what are people's practices. In terms of the Arturo guy, it was a person. So, if you look at 1.7C1, it talks about a personal relationship and there any sort of financial gain. So question, right? Is it sort of a financial, if you're in a networking relationship with him? Possibly not. He's not a party or a witness. And so there's also 1.7D, which, you have to reasonably believe that the lawyer will be able to provide competent and diligent representation to each affected client. And then the last part we were talking about where Marissa was like, oh, I could just sign it right now. We want to make sure that we're passing some sort of like procedural unconscionability. So you're just not handing someone a waiver and standing over them and saying, sign it right now. You don't worry about it. You don't have to talk to anyone, just sign it. So there might be some sort of a procedural unconscionability that you need to protect yourself against. And any sort of questions here? I think not. So, okay, good. Scenario 2. Oh, me, sorry. Here we go. Hey, Jenny. Well, you passed conflicts and thanks for signing the conflict waiver. I sent over an engagement letter for you to review, but you mentioned you had some questions.
Yeah, thanks for talking this through with me, and sorry again for the 11 p.m. text. My brain just focuses better at night for some reason. Anyway, I see that you're asking for a retainer. Is that really necessary? Our parent company has given you a lot of work in the past. I don't really feel like, it's overkill, you know?
Well, yeah, I think our policy is that we're going to at least need a retainer of $5,000 before we begin work.
Well, I think our parent company has a retainer with your firm. Can you just like apply that here, since we're pretty much the same company as I've told you before?
Well, we're going to need to get your parent company's permission to do that. I just can't, start sharing retainers across the board. I can give the CEO of your parent a call. Is that okay? And we can just get him to confirm. Do you want to do that?
No, don't bother them. Don't let them know. We'll handle it. We can get the retainer. But can you just like go ahead and start the work now? And we can follow up with you about the payment, because this seems like a really pressing issue. We haven't really been sued yet, but I'm really afraid it's coming, and I really want to understand what kind of liability we're facing.
Well, we can make it super easy for you, and you can just like bring down a check right now, or you can wire transfer the funds, and that would be super easy, right?
What about a contingency case? Like, let's say we get sued and you can evaluate if we can countersue them. And then if you win, like you get half of the money, or can't we just sue them for like a frivolous lawsuit? Because, it seems like some of this might be made up maybe, or you could work on a success fee. I feel like my other lawyer friend, she does this for clients all the time. So, or a fixed fee, like something like that. I just, working out some spitballing ideas.
Sure. Okay, let's kind of just break that down here. So a fixed fee isn't really going to work here. Normally we do a fixed fee if we're doing like a set kind of contract, like if I was drafting an employment contract or an NDA, or if I was helping you set up a formation of an LLC where we knew the amount of work that was actually going on. But in terms of the things that you're talking about here, it's really kind of open-ended. So we really don't know, what's going on, like how long that we're going to be working on this case together. So a fixed fee really isn't right. In terms of a contingency fee or a success fee, again, probably not the right situation here, because you talked about a frivolous lawsuit. I would highly suggest that we don't pursue that action. It's going to be a situation where we'd have to investigate the facts further. We'd actually have to see if the plaintiff actually was completely lying about things and had taken some egregious action and verifiably lied about those things, and the case was completely without merit. So you're not going to be looking at a situation where you're going to be getting money back from the plaintiff. So a contingency fee case really isn't going to work out for our situation, and I would recommend against filing a frivolous lawsuit and not even bothering to look at those things. It's just not worth your time. Really here, we're going to be doing an hourly rate and a traditional payment rate. So my hourly rate is $2,000 an hour, and my associate's rate is $1,000 an hour, and my paralegal's rate is $600 an hour. So that's what we're going to be doing.
Wow. I guess the hourly rate thing makes sense, but that seems kind of high. Okay. On the retainer, how much would you need?
Well, we're really going to have to know more about the case and how much work I think we're going to be doing in the next few weeks. And since this really isn't an active litigation case, you told me that they hadn't filed any sort of lawsuit and that the woman had just quit. Well, I don't think that we're going to need as much in that kind of retainer, since it's, not a defensive and action lawsuit.
Great. My only comment would be, this seems a little bit formal. I like to do business based on more like trust relationship basis. I guess we can send you a check, but do we really need all this in writing? It just seems like it's going to unnecessarily slow things down and make this more complicated.
Yeah, I know it seems like it, but really it works out better in the end. So we're going to ask you that you signed your written engagement agreement. And so you and I both can understand what our respective obligations are.
I guess that makes sense. In terms of work, though, I have seen attorneys run up the bills, and I really don't want you spending a bunch of time doing like a deep analysis or like writing anything up or summarizing our calls, because one, that costs money, and two, I don't really want a paper trail of this. So can you maybe just look at the file and then like call me with what your gut instinct is? I just kind of want to know if we're in trouble or not.
Yeah. Okay. So there's going to be some attorneys who would actually work with you in that sort of arrangement. That's not going to work, in terms of the way that we work. And so I find that it really helps if I'm going to be talking with you and we're going to be discussing the situation. I'll be telling you about your different legal authorities. I'll be telling you what kind of steps you can take after that. And then you and I will decide, well, what are you going to do? And you're going to make a decision. Then I'm going to go ahead and write that up to you. And I'll usually do it in an email. So then you can think on that. And you'd really be surprised that in the moment when you're talking to me on the phone, you might think one thing, but then when you see it in writing, you might actually take another step. So it's always just worth it so that you can understand all of the things that we're talking about. You can really understand the legal authorities and then the impact of what your decision is going to make. So if you're going to actually retain me, that's the way that I work. And so you are going to be seeing confirmation emails from me in terms of here's where we go next. This is what you decided to do. So not all the attorneys work that way. So you can really just decide, is my style going to work for you? Or should you be going with someone else who's really kind of more, seat of your pants? And that's fine. There's no wrong or right on that one. It's just in terms of what works for you and what works for me.
Sounds all very complicated, but okay. My only comment would be that since this is kind of a pretty delicate case, I only want you working on it, or maybe another partner. I don't really trust those associate attorneys. I really want somebody senior on this, your most important people.
Okay, so we have a team of people working with me and we're all at different rates, and we want to go ahead and build this in the most efficient way possible. So there's going to be some situations where there's going to be lots of legal research. You don't want someone at my rate, at my partner billing rate at $2,000 an hour doing that legal research when you could be having someone else, whether it's the one of the associates at a much lower billing rate. So what we try to do is staff the case appropriately depending on the type of work that we're having them do. So I think you're going to find that this is a much better way to handle your case. Again, not all firms are like this. Some firms only have the partner working on it, and it can be efficient for those reasons, but this is the way that we work in our case.
Okay, I guess that makes sense. Let me take another look at this with all that in mind, and I'll read the engagement letter and I'll send it back if we, agree to move forward.
Okay. Okay. So scene. So we talked about fee letters. So you should be writing a fee letter in writing. Make sure that your client has time to review. You're going to be encouraging them to do independent counsel. There is a whole section in the model rules in terms of rates and the reasonableness of it. So query, is $2,000 an hour a reasonable rate? Maybe, probably kind of steep there. So you'd be looking at terms of what are the other attorneys in the area charging for that type of work? Is it just out of the sky? Because we know that there are some really big firm lawyers who are charging at that rate, but is it really appropriate in this kind of work? It's a question. Other things. So we talked about the retainers. We really kind of were trying to see what's appropriate in terms of retainers. In this case, it didn't come out here, but we'd set it up so that the parent company actually was a slow pay client. And so they weren't good. And so, sometimes for the big institutional clients, you won't have any retainers at all. But what if you have a client who actually doesn't pay very well or on time or is slow? So in that case, you might want to get a retainer to protect yourself. It's something that you just need to think about. Don't get burned. Little companies, particularly where you don't have a strong relationship, it's very helpful. Let's see. Oh, in terms of having a retainer, again, this was pre-lit, right? So usually our retainers are going to be smaller in terms of the pre-lit amount versus if you're in litigation, it's much harder to withdraw once you're in litigation. And then, of course, you're not going to be charging for the time when you're making any sort of motions to withdraw. So just think about that in terms of what is your threshold versus pre-lit versus lit. Is it 25,000? Is it 50,000 in terms of taking a litigation case for actually having to think about extricating yourself? You can't use retainers for other related parties, like in this case, the parents. Don't use your sister subs retainers unless you actually have express permission from the company who had actually paid the retainer in the first instance. Let's see. Oh, this oftentimes happens. Like some clients, they just don't want to spend money on detailed review and analysis and written memos or summaries of calls. And that's really a business decision. So sometimes insurance companies in particular will say, we don't pay for this, this, and this, and this. And if it's important to you to have the work from the insurance company, then maybe you might say, that's fine. But or maybe you wouldn't say, that doesn't meet my profits, right? I can't pay my overhead. I can't do these sorts of things. So you need to be able to set expectations with your clients about what you're going to be paying for and what you're not going to be paying for. And in terms of the follow-up work that you're going to be doing. And then let's see, sometimes people want partners to work on the case. I think that was self-explanatory. And anything else? Oh, I see David Ratner wants to charge out for $2,000. Sounds great. And then let's see. Oh, would I want this client? We're going to get there. So just in a little bit, we have another scenario. We're going to 115, right?
That's right.
Okay. All right. Scenario 3. Okay. Thanks for signing the engagement letter. Why don't you tell me a little bit more about this case?
Sure. So, I mean, I really blame the gym, like, why do even people feel the need to exercise? It just causes all of these problems. And I mean, Brett is super charismatic and I do hear he's easy on the eyes, but weirdly, everybody's confused because he's not married. Although I do hear his total ego and it's kind of a Casanova. So maybe that's why. I mean, I don't really know that much about the situation personally, but it sounds like the whole office thing might have been an accident or a misunderstanding. I mean, seems like HR seem to think so. I haven't met this Maria person personally, but I do hear she's a little shy and uncomfortable around men. So it seems like this might have been a miscommunication thing. But on the other hand, I don't really like it when people get in my space either. So
Okay. So hold on just a second. Let's just back up a bit. There's a lot of information that you went over, and maybe let's just take this in smaller pieces. So you said you had an employee and Maria quit, and that there was a sexual harassment issue. And so what's Maria's position?
Maria Campbell. So she quit last week. It was very dramatic. She apparently ran out crying and everything. It was really bad.
Okay. So we're going to want to get back to that in a little bit. That's really important. But tell me, what was her role at the company?
Oh, I think she was Brett's assistant, something like that. Brett is the person who's accusing her of harassing.
Okay.
Him.
And when did she start working at the company?
I think 2 or 3 months ago. I mean, I don't really know, to be honest. I'm not really involved in the day-to-day minutia. I know kind of big picture stuff, but not really any of these smaller details. And I don't really have time to get to this right now. Can I just send you a memo or something? I can have my HR person draft it up and send it to you.
Okay. Well, yeah. So why don't you go ahead and take your best shot in terms of putting something down, or the people who actually know, and they can go ahead and put in a memo. Can you also send me her personnel file, her pay stubs, timekeeping records, any other documents that you had related to her complaint, to the extent she ever made a complaint to the company?
Yeah, I don't think we have any of that stuff.
You don't have her personnel file?
Not really, no. We were storing all of our personnel files on the service provider in the cloud, and there was a huge network error where we were trying to switch to another provider and a bunch of documents were deleted. I think there might have been a backup, but the file might have been corrupted. I don't know. So this only happened to a handful of people. So Maria was probably one of them.
And why do you think why do you think that's the case?
I don't know. I mean, she quit recently and she's not really relevant anymore and making all these complaints. So, her information might have disappeared.
Okay. Well, do you know what the name of the original cloud service provider was? Can you see if you can chase it down? Maybe ask them for a copy?
Yeah, I mean, I guess so. I guess I didn't really think about that.
Well, did the company do an investigation, either an internal one, or maybe you hired an outside person to do the investigation? Maybe we can look there.
I mean, there might have been a report, but I don't think it exists anymore.
Wait, what do you mean? Why not?
Well, I don't have it.
Well, have you ever seen it?
Maybe. I think it got lost.
Wait, what do you mean it got lost? Do you mean that you lost your copy? Are there other copies? Do you think HR has a copy? Does your CEO, did he ever get a copy? Did you have that outside investigator? Maybe we should call them and see if we can get it from them.
HR did it in-house, but I mean, they're so overloaded with information. I really doubt they could find it.
Okay, so why don't we do this? How about you give me the name of your HR person and I can run it down with them?
I guess. If they find it and it turns out it's bad, should I have HR revise it before sending it to you, to make us look better? I think it might have just been a draft on someone's computer. So I think we can edit it for a final version,
I'm going to say no. This is really important. I want you to understand the documents that were created in the past. You cannot go back and change them. It's like a freeze frame. If the memo is in a draft form, it's got to stay that way. Writings that were made contemporaneously at the time of the event, and here it was this alleged sex harassment, those writings are evidence, right? You don't want to be changing evidence or have it conveniently disappear or be lost. And if you do, your credibility will be shot and there may be massive damages for the company. You cannot do that. Is there someone else at the company who would maybe be more personally involved? Maybe you made HR, they might be able to answer my questions better about the details of the case and the documents.
Yeah, it's probably a good idea. Her name is Wanda. I'll put you guys in touch. I really do have to go to a meeting now though, so I'll text you if I think of anything relevant.
Okay. Okay, great. Thanks. So scene, let's see. Red flags here, and would you want to keep this client? No, I wouldn't. But we'd set up. So if you have a client, we kind of tried to do this where the client was lying to you. You have like a liar of a client. And so if it's a big company, maybe you can take that person out of your right information gathering part. And so that person isn't going to be someone who you rely on or you call as a witness, and you just don't want to work for a liar of a company or a liar of a person. So, you know, normally I would just be like, no on this guy, but I think the scenario is set up that we're going to continue to work with this person. We also set it up so oftentimes the clients will come in with a ton of information and too much, and it's really jumbled and incoherent and it's unreliable. So we normally want to take the time to break it down with your client, try to get the big picture, try to get a detailed chronology, facts, witnesses, documents to support it. Sometimes the clients are either too jumbled, too busy or whatnot. So instead we'll try and get it in a written memo. Sometimes those work, sometimes those are way too detailed. Have it again in a chronology form, ask for backup documentation. We set up also in terms of what happens in terms of documents being lost. And, you know, there's a question in terms of, do you do a litigation hold? And I'd want to hear from the other members here. Do you ask for a litigation hold on your clients, on your corporate clients, when there actually hasn't been litigation which is filed? And then if there's documents that are missing, what do you do to chase them down? Who might be other holders of the documents? Maybe there's third-party people who you could get without having to do a subpoena. And then, you know, we've seen situations where, or Marissa, maybe you can talk about like unreadable forms and stuff.
Yeah, we've had a couple of cases where either, like we were saying, this is actually a very similar scenario to what we've had to deal with before, where the client's documents got lost, and we've had to go back and like really push them and be like, okay, well, where were they stored? Like, do you have a hard physical copy located in your office? And sometimes they do, and sometimes they don't. And then we've also gotten data dumps where we've just had these Excel sheets that are unreadable, and we've had to go back to kind of the provider of the data, so usually the timekeeping and payroll records, and ask them to see if they can, you know, include different headers or, you know, let us know where the data came from. So we have kind of a better way to read and understand the data. So just being creative about like where the data is coming from, following up with your clients, like really kind of keep pushing them until they can provide you with either more information about the data itself or trying to find different avenues to locate like lost data.
And we've had situations where we went to the payroll provider and the payroll provider had lost the data. And so, right, so that normally you rely on your payroll data, and then they'd had their own computer problems. We ended up chasing it down in different ways, but it was, you know, like sometimes things go wrong, they like go wrong crazy.
Especially relevant now too, that the statute of limitations on some of this stuff has changed as well, so.
Yeah, okay, so let's see. What else did people hear? So David had talked about 3-step intake. Okay, and Beth gave other information on legal aid. Okay, all right, scenario 4. Fact follow-up, document retention, joint representation. All right. Okay, so we now have a new person. Hi, Wanda, you're the HR director, right? Thanks for the fact memo. It had a lot of details, but I still have a few outstanding questions.
Sure, happy to answer any questions you have.
So you sent me a large Excel file with a lot of numbers in them. Can you explain what are those?
Oh, yeah, I think those are time records. I'm not sure if Jenny told you, but we had an issue when we switched payroll providers recently. They were originally in a more readable form, but after we stopped being a client, they stopped posting our information in an accessible form, and they put in this weird code. So we went to get it. They put it on a drive for us, but it was just the raw data, and the layout is a bit confusing.
So is there a way that you can go back to the provider and ask for just the information maybe that's relevant to Maria?
Yes, I can see if they would be able to do this. Let me just make a note.
And can you also do it so that we can see the dates of her employment and her pay? And have you been able to track down that investigation or report made by HR? Jenny said that she lost her copy and wasn't sure if there was another one. Do you know who performed the report? Do you have a copy?
Yes, in fact, I was the person who did the investigation
Oh,
and prepared
good.
the report. I can send it to you. We always keep a copy. I was able to pull that for you, and I will send it to you after our call.
Okay, and then after you completed the report, did you send it to your management team? Has the report been altered in any way since it was completed?
I did send it to management, and it has not been altered in any way. That would be against company policy.
Okay, I'm really glad to hear that. And did you work with an attorney when you're performing the investigation or preparing the report?
No, we did it in-house.
And
But can I ask you a question first? Sorry.
yeah, of course.
Great. So first of all, Brett, Maria's supervisor, he was the one to have alleged to have harassed her. He's been asking me a lot of questions. He's very nervous about this case. Can I put you in touch with him? Like maybe you could represent him as well, because I feel like you'd be able to answer his questions better than I have been able to.
Yeah, okay. So first off, I just want to get this clear. I represent the company and I don't represent any of the officers or the employees. I don't represent Brett, and I wouldn't be providing legal advice to him with respect to his interests. I may want to interview him, but if I did, he'd need to understand that I wasn't his attorney. And while his interest and the company's interest may be aligned at this point, without knowing more about what happened, I think that we would not represent Brett at this time. If he wants to retain his own attorney, then that's his right to do so. You should know, however, that if this matter progresses to a lawsuit, then the company may have an obligation to defend and indemnify Brett for the actions that were within his scope of work. That would mean that you, the company, would have to pay for his reasonable attorney's fees and costs.
Oh dear. Does that mean that Brett can hire whoever he wants, like a celebrity attorney, and we have to pay his attorney's fees? Or can we hire our own attorney if he refuses? Do we have to pay for his attorney? Like, how does that work?
Yeah, so under Labor Code 2802, the employer only needs to pay for the necessary expenditures incurred in carrying out their employees' job duties. And this has been interpreted to mean reasonable attorney's fees, but not the most expensive attorney's fees. So not the Cadillac attorney. And if you offer to provide an attorney to Brett and you pay for it, if Brett refuses your choice of counsel, then he's going to have to pay for his own attorneys, and you don't have to do that.
Great. Okay. So Maria quit. Should we chase after her and offer her job back? Or do we have a sense of what we should do with Maria or Brett or the company? Like, where do you kind of fall on all of this?
These are all really good questions, but I think at this point in time, we're going to have to actually go and get more information from you. So before I give you advice and tell you what it is that we're going to be doing, I'm going to want to look more in terms of the information that you have, talk to some witnesses and kind of see, and then we can kind of regroup. Okay.
Great. That makes sense. So I'll send you the documents and maybe we can touch base after you've had a chance to review further.
Okay. Okay. Scene. Any other questions? Call Marta back. Overly dense fact memos, in terms of, again, breaking it down. We just talked about how we getting the payroll data in unreadable form. So trying again to ask more questions on how we can get that information so it can be readable so that we can actually produce that later on if we need to, if we're in litigation, to the other side.
It's not more than you would think.
Yeah. And kind of how data sometimes gets corrupted when it's stored. So then sometimes either your company or your client's company or their third-party providers will then, if it's not active, then they'll store it. And then in the storage part and then coming back and getting translated, it comes out gobbledygook. And so then we would ordinarily encourage the client to pay for someone to try to translate all of that information so we can put it back into readable form that, normal people can read. And then also we tried to set up the, asking for advice before you actually do a complete fact analysis. Other things, Marissa?
Just the joint representation. So, when you have to represent somebody, when you have to pay them.
Yeah. Yes, exactly. Okay. Yeah. And so there's the case of Carter versus Entercom Sacramento, where the Court of Appeal concluded that the employee's legal costs are not necessary where the employer or its insurer is willing to provide legal counsel to the employee free of charge. Accordingly, employers have no obligation to indemnify employees under such circumstances. So just a little sight for you. And that is it for us.
Before we leave, I've got actually a question for everybody and one for Terry. Do you recommend that people image computers at this point in time, or when do you recommend that? If you do.
Image computers?
Yeah, if somebody's been using a laptop, anytime you turn the laptop on, it actually changes the data, or any computer, and you can send it out to get a snapshot, if you will, an electronic snapshot of what it looks like at the moment. And then you can continue to use that computer instead of having to put it in storage. So that's one thing that I often try to get small businesses to do, is image the computer as soon as I know that there might be a dispute. Costs a little money, but you've got the documents then frozen in time, email, how it's been used. You've got, if you've got an employee who's been spending a lot of time on the internet, you can track that instantly if you've got the image. And so that's one thing that I like to think about in the intake process. And yeah, if you don't have a complaint yet, you don't really know what you got to store. So how do you do that? And then the other thing, Terry, if you had decided that you liked Maria's case, would you have asked her for authority to get her personnel file and records right from the get-go?
Well, I would have obviously said, hey, here, let's move forward. I'm going to send you the engagement agreement, work through all of that. And then with the engagement agreement, if we are moving forward, I send a waiver to them that they, were able to request and receive documents so we can get that started. And I say the first step for us is requesting a personnel file, payroll records, and I have, a template with a litigation hold. So I send that right away to the company with our request for, everything that they can send that to us in electronic format with the litigation hold. And frequently that sort of gets the ball rolling in terms of, having Audrey or Marissa contact me. Hey, let's chat about this. And, we can start that process in terms of making a demand or trying for settlement, depending on how things go.
And 30 seconds left. Anybody want to answer? How do you advise your client with regard to social media?
Oh, I have a beautiful sheet that I sent to them with the engagement letter. I would say concurrent with, because now they go out separately. So they understand the seriousness of, it's not just social media. My clients like to talk about their matter with the friends who are not married to them and are not their therapist and are not their priest. And I'm like, that's absolutely unnecessary. You're just going to have so many witnesses deposed in this case about what you're saying about your case. That's going to drive us bonkers. So we tell them to be very careful about how you communicate, about what you communicate about. I've had cases, substantially reduced in value because the client posted themselves exercising after claiming that they have been whiplashed. So yeah, just don't do it.
All right. Well, I want to thank all of you. I thought this was an excellent program. Acting phenomenal. Questions even better than that. I think people stayed engaged, and I was fascinated, even though I've been doing this for too many years. So thank you all.
Thanks, everyone. Nice.
Thank you, everyone. You guys did great. Everybody, have a great rest of the day, and we will get you your information and your certificates very soon. Thank you, everybody.
Thank you.
Thank you. Bye.
Hey, Anne.